Hey everyone, welcome back to the VSO Gun Channel. It's great to be here as always. Thank you for tuning in. And today we're continuing our discussion about the Rahimi case. Now, I did a video on the main opinion of the court, but I think there's so much stuff packed into the Rahimi case that I think it is important that we continue to discuss it because there are so many different perspectives in this thing that are kind of all over the map. Never have I seen a Supreme Court decision that has spent more time talking about something other than the case at hand in such a large document. And it is my opinion that there is a lot of posturing going on in this document because there was a section that I read that talked about how Second Amendment case law is actually really young because it really started after the Heller case. So I think that all of these justices are looking to put their mark in history to be referenced later on. And that's why in this decision, we have the main opinion, 5 concurring opinions, and 1 dissenting opinion written by Clarence Thomas. You've heard a lot about that one and the main opinion, but I want to spend a little bit of time over the course of the next couple days doing videos on the other 5 concurring opinions that were crammed in here. 1 by Barrett, 1 by Gorsuch, 1 by Kavanaugh, 1 by Jackson, and 1 by Sotomayor. I'll probably combine Gorsuch and Barrett and probably combine Jackson and Sotomayor because they're very similar. But today we're going to spend some time on Kavanaugh. And the reason why is because I think that this is possibly the most important part of the whole decision for you as an American citizen to read, to understand how the Supreme Court makes its decisions, how justices, past, present, and future, should go about making decisions as it relates to cases that are before them. Real quick, capitalism break. Hear a word from our sponsor, and we'll hop into what Kavanaugh actually said. We have 2 discount codes prepped up for you guys over at Mission First Tactical. One is for the all-day everything stuff, everything from their backpacks to their drinkware to the holsters to even the new translucent magazines that they just came out with. Really like the purple ones, by the way. And then a second code that is for everything that is getting ready to go away, like 50 or 60% off in many cases. So you can find all that information over at the affiliates page, and special thanks to Mission First Tactical for making today's video possible. If you want a reference point, then in the document, Kavanaugh's concurring opinion starts on page 36. The American people established an enduring American Constitution. The first and most important rule in constitutional interpretation is to heed the text. That is, the actual words of the Constitution, and to interpret that text according to its ordinary meaning as originally understood. The text of the Constitution is the law of the land. As a general matter, the text of the Constitution says what it means and means what it says. And unless and until it is amended, that text controls. In many important provisions, the Constitution is a document of majestic specificity with strikingly clean prose. And then it goes on to give an example of how elections and term limits and things like that and voting is supposed to happen as it pertains to Congress, the president, et cetera, et cetera. Of course, some provisions of the Constitution are broadly worded or vague, to put into Madison's words, more or less obscure and equivocal. As Chief Justice Rehnquist explained, the Constitution is in some parts obviously not specifically worded document, but one couched in general phraseology. That is especially true with respect to broadly worded or vague individual rights provisions. For example, the First Amendment provides that Congress shall make no law abridging the freedom of speech. The Second Amendment at issue here guarantees that the right of the people to keep and bear arms shall not be infringed. Read literally, those amendments seem to grant absolute protection, meaning that the government could never regulate speech or guns in any way. But American law has long recognized as a matter of original understanding and original meaning that constitutional rights generally come with exceptions. For example, the First Amendment has permitted restrictions upon content of speech in a few limited areas: obscenity, defamation, fraud, and incitement. So too with respect to the Second Amendment. Like most rights, the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. A recurring and difficult issue for judges, therefore, is how to interpret vague constitutional text. That issue often arises, as here, in the context of determining exceptions to textually guaranteed individual rights. To what extent does the Constitution allow the government to regulate speech or guns, for example? In many cases, judicial precedent informs or controls the answer. But absent precedent, there are really only two potential answers to the question of how to determine exceptions to broadly worded constitutional rights: history or policy. Generally speaking, the historical approach examines the law, practices, and understandings from before and after ratification that may help the interpreter discern the meaning of the constitutional text and the principles embodied in the text. The policy approach rests on the philosophical or policy dispositions of the individual judge. History, not policy, is the proper guide. For more than 200 years, this court has relied on history when construing vague constitutional text in a manner of constitutional disputes, for good reason. History can supply evidence of the original meaning of vague text. History is far less subjective than policy, and reliance on history is more consistent with the properly neutral judicial role than an approach where judges subtly, or not so subtly, impose their own policy views on the American people. That's the primer that I'm going to give you from what he wrote. I very much suggest that you go read the rest of it because it's very good. And he continues on for several pages discussing policy and history. The thing that I think is really interesting is he discusses pre-ratification history and post-ratification history and how they should weigh. Particularly interesting, I thought, was when he talked about pre-ratification history, as in there were things in the world that existed and what bearing they had on the manufacture of the Constitution and what things were expressly left behind. Because remember, this happened in 1791. What existed before that? And remember, we had just fought a war against the British Empire. What things did we expressly say, hey, you know that thing that they do over there under the king's rule? We are not having that crap here. And I think that bears an important distinction, because when we talk about the text, history, and tradition in the United States, it must be the text, history, and tradition of the United States, not necessarily just crap that existed at the time, which I think is very good. Now, as this relates to this particular document, I think this is actually a very passive-aggressive move on his part, because when we get to particularly Sotomayor and Jackson's, which I think I'll do next as a good contrast to this one. If you read this whole segment and then read what Sotomayor and Jackson wrote, he is clearly casting shade on what they wrote, because they very much, as you will see soon, want more of a policy position than a historical position. That's what I've got for you today. Again, very good read from Kavanaugh. You should go check that thing out. And I'll have a link to the actual decision in the pinned comment down below, so you can go run it down and check it out for yourself. Thank you very much for tuning into the VSO Gun Channel. We'll see you again here pretty soon, hopefully. Anyway, provided we don't get censored.